All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati&Haradinaj.
Thank you, Madam Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon to Your Honor and all those in the courtroom joining remotely. Appearing for the Specialist Prosecutor's Office today are Alex Whiting, Deputy Specialist Prosecutor, Matt Halling, Associate Prosecutor, Valeria Bolici, Prosecutor, Lena Peterson, Case and Evidence Manager, and I am James Botch, Associate Prosecutor.
Thank you, Mr. Prosecutor. Now let me turn to the defense. Starting, I don't know if it's with Mr. Rees or Mr. Bowden, because I think there was a problem of connection with Mr. Rees. So, Mr. Rees or Mr. Bowden, you have the floor.
Your Honour, this is Jonathan Rees. I'm appearing over Zoom remotely on behalf of Mr. Gucati. I'm assisted by Mr. Bowden, co-counsel, and Miss Ellie Stevenson is also present to assist.
Thank you very much, Mr. Rees. I understand that you had some last-minute changes related to the place where you can attend this status conference remotely. If you have any struggle to follow the debates, or if you want me to repeat, please feel free to intervene or to communicate with the court officer so that you don't miss anything in the hearing.
I'm very grateful for that, Your Honour, and I'm very grateful for Your Honour allowing me to attend without video, as it were, for this hearing in these exceptional circumstances. I'm grateful. Thank you.
You're welcome, Mr. Rees. Now I turn to Mr. Cadman, please.
Good afternoon, Your Honour. Mr. Cadman appearing for Mr. Haradinaj in person. Mr. Buckley is joining us remotely. Mr. Buckley is Specialist Co-Counsel, and Ms. Boxberg is with me in court, who's legal assistant.
Thank you, Mr. Cadman. And now let me turn to the registry.
Good afternoon, Your Honour. My name is Rolf Roach, Head of the Judicial Services Division in the Registry, and also we have Mr. Stefan Wolfart, the Deputy Registrar. Thank you.
Thank you very much, Mr. Roche. And for the record, I'm Nicholas Guillou, Pre-Trial Judge for this case. On 9 June, I scheduled the 6th status conference for this case. On 23rd June, I rescheduled this hearing when I ordered the submission of a corrected indictment following the decision of the Court of Appeal on the preliminary motion filed by the defense. On 5 July, the SPO submitted the corrected indictment. On 12 July, the Gucati and the Haradinaj defense submitted their respective pretrial brief. My goal today is to review the status of the case before the transmission of the case file to the trial panel, which I set in the order for a revised calendar for 16 July. In particular, I wish to discuss the detention facilities, translations, disclosure, the status of defense investigations, and the transmission of the case file and readiness for trial. I thank the Haradinaj defense for their written submissions, and as usual, I remind the parties, should any submission require the disclosure of confidential information, to indicate this to me so we can go into private or closed session. I would like to start our hearing today with an update from the registry on the measures taken in relation to communication between defense counsel and the client in the detention facilities. I note that despite acknowledging the steps taken by the registry to improve the situation with the introduction of computer screens, the Haradinaj defense maintains the previous concerns raised regarding communication between counsel and the accused. I invite the parties to indicate if the latest measures implemented by the registry respond to their concerns. And I would also like the registry to give us the latest update about the possibility to organize family visits given the evolution of the COVID-19 pandemic and the evolution of the vaccination campaign. Mr. Roche, you have the floor.
Thank you very much, Your Honour. Firstly, regarding the detention facilities and the ability of counsel to meet their clients directly. Throughout the entire pandemic, we have worked very, very closely with the medical officer of the detention facilities and also with other relevant parties. And I'm happy to say that as of the 1st of July, visits between counsel can be in person as they were, but also without any separation. So there's no glass partition and there is no requirement for them to be physically separate. That was as of 1st of July for counsel who are fully vaccinated and are coming from green or yellow countries. As of 15th July, tomorrow, that relaxation will apply to all counsel, irrespective of vaccination status or where they are travelling from. In the meantime, of course, we have been implementing a range of measures such as the secure electronic data sharing scheme, putting in extra screens, etc. But obviously, the latest measures, I think, will further improve the ability of counsel to meet directly with their clients. As regards family visits, due to the general improvement in the vaccination programme and, again, closely following medical advice, in-person family visits will commence as of tomorrow. I understand that a number of visits have already been planned and are expected to occur subject to travel arrangements over the next couple of days. So again, these are in-person, face-to-face family visits. So, if Your Honour would like any more details on any of those issues, I can provide it.
Thank you very much, Mr. Roche. I will now give the floor to the defense, and especially to indicate if they still see any problem with the evolution of the measures as described by the registry. Mr. Rees, please.
Your Honour, firstly, we're grateful to the measures that have been introduced thus far. They do assist. We are still looking forward to the position where we can meet face-to-face without any physical obstruction or barrier between counsel and lay client. We understand that that is a step that we are rapidly moving towards, and we look forward to that. There are measures in hand to plan for family visits. Again, we're grateful for the cooperation there, and we look forward to those plans coming to fruition shortly. There's nothing further that I wish to add specifically on this point, Your Honour. Thank you.
Thank you very much, Mr. Rees. Mr. Cadman, please.
Thank you, Your Honour, and may I also extend my thanks to the registry for putting the measures in place that have made a huge difference. I can say that I had the first visit with Mr. Haradinaj yesterday and today. I was also graciously given a tour of the various different improvements that they've made for both family visits and for detainee visits. There is, of course, still a glass partition on the desk, but obviously we understand the reason for that. And certainly Mr. Haradinaj is very grateful for those steps that have been taken. It is regrettable that it's taken until now, when the case is on the verge of being transferred to the trial panel, for those steps to be implemented. But I cannot fault the registry for what they've done, and certainly we are very grateful for those steps that have been taken. The criticism that I made in the written submissions were made prior to seeing the facilities as they are now. And that was primarily because even with the screens, with the separated glass, it still relied on the telephone system to be able to hear, and so it wasn't an ideal situation. That, of course, has now been resolved. There are two screens in the room. We can connect our devices to those screens, and so it is a welcome change. The concern that we have, obviously, is not something that the court or the registry can predict. just today we were told that the likelihood of the Netherlands going back into an orange or deep red situation is going to have an impact, and we may well find ourselves going back to the situation that we've been previously. Again, that's not the fault of anyone in this building. It's just the reality of what we have. The family visits are incredibly important, and we're very grateful that that's being moved forward. Mr. Haradinaj has been detained for 10 months without having any access to his family. We would also encourage the registry to facilitate consular access. We are aware that the Ministry of Justice have requested visits with detainees that have been refused for whatever reason. These are matters that do need to be taken into account. But certainly the situation that we have now allows for us to sit down with documents, with videos, to take full instructions. But of course, as we're now going to the trial panel, or about to go to a trial panel, it's still going to take some time before we're going to be ready for trial. But certainly Mr. Haradinaj wants to make it clear that he is not seeking to delay matters any further after being detained for 10 months and matters that he do not consider are valid. He really wants to move this forward as well. So we will continue to work with the registry on that.
Thank you very much, Mr. Cadman. Mr. Roche, do you want to say anything about the issue of consular visits? Because this is something that has been raised by Mr. Cadman. Is there a specific point you want to mention on this topic?
Thank you, Your Honour. Consular visits will be permitted in person as of, my understanding is tomorrow, the 15th of July.
Thank you, Mr. Roche. I turn to the prosecution. Do you want to say anything on this topic? I guess not. Thank you, Mr. Prosecutor. So now let us move to the second item in our agenda, which is translations. In particular, if there are any remaining concern of the defense as regard translations required by law. I would first like to hear from the registry, again, about the current state of translation in this case, and if there are documents that still need to be translated or revised. I would then like to hear from the parties if there remain any difficulty related to translations. I note in that matter that the Haradinaj defense expressed concerns that some documents were not translated. I invite the Haradinaj defense to indicate if any filing or material are still to be translated in Albanian according to the working language decision and my framework decision on disclosure. Mr. Roche, you have the floor.
Thank you very much, Your Honour. As regards translations, there are no outstanding translations which are required to be translated under the law. As updated at the previous status conference, these were provided in full by the 15th of June. A slightly revised indictment and other documents were submitted by the SPO, and the updated translations have been provided last week. So in terms of outstanding translations, there are no priority translations requested by the defence in this case. And as is the case in all cases, all filings are automatically submitted for translation, and that is ongoing. But in the event that a request for priority translation is submitted, that will be dealt with in accordance with the appropriate policy. Thank you, Your Honour.
Thank you, Mr. Roche. Let me now turn to the defense, starting with Mr. Rees, please.
Your Honour, I'm aware that Mr. Cadman has drafted some detailed submissions in writing on this very point, and I'm grateful to him for that. I will adopt his position, and I'm grateful to him for taking the lead on this issue.
Thank you, Mr. Rees. This is noted. Mr. Cadman, please.
Your Honour, I don't really want to go over what's already in those written submissions. What I would say is that there appears to be a difference of opinion as to what is required by law and what the accused are entitled to. I've made it quite clear in the written submissions that this is an institution of the Republic of Kosovo. The accused is a citizen of the Republic of Kosovo. He is entitled to have all material that the prosecution seeks to put forward in a language in which he understands. The reference to priority material and what is required by the KSC law, we do not accept that that is a sufficient basis. And again, we can make a filing in relation to the documents that we consider are still outstanding, that are required. I appreciate that the translation unit is having to work on 4 different cases at the moment, and there are different priorities. That is understood. But this matter cannot possibly go forward until all of the material that is to be presented is translated and made available to the accused in this matter. We maintain that position, that it is not a question of a foreign national appearing before a foreign court. It is a question of a national appearing before a national court, even though it may be staffed entirely by internationals. That is not Mr. Haradinaj's concern. His concern is to be able to review all material and provide instructions to his counsel. He's not able to do that if he's not able to go through all the material. I cannot summarise, as his counsel, thousands of pages of documents to him in order to take instructions. He has to be able to have access to all material, and this matter cannot possibly go to trial, so cannot possibly start a trial until that is done, and we maintain that position. If it assists the registry and it assists the court, we are more than happy to put in a separate filing setting out all of the material that we seek to be translated before this matter can go forward.
Thank you, Mr. Cadman. Just to understand exactly your point on this topic, are you basically telling me that you disagree with my decision both on working language and the framework decision on disclosure, especially paragraph 61 to 64, in which I set all the documents that need to be translated, and I set the procedure for the defense, or actually any parties, to contest this and how it should be solved? Or are you in agreement with this framework, and is it the execution of the translation by the registry that is of a concern? And if it's the latter, what document are you referring to? Is it? Can you list is it one in particular, and what is it? Thank you.
Well, Your Honour, as has been mentioned before, the decision on the working language of the court was obviously taken before I was instructed as counsel in this matter. I understand that that decision was made at the outset of these proceedings. The position is that there remains documents which I'm more than happy, I'm not prepared to go through a long list of documents at this stage, but I'm more than happy to put that into writing, what documents we consider, we require, we need to have translated, put that to the registry. It may well be that we need to come back before Your Honour in relation to that point. The position is that it is not sufficient to merely focus on the core documents that the defendant is entitled to. It is the entire case file. It is all material that has to be translated.
Mr. Cadman, in my decision, my framework decision on disclosure, which is dated 22 January 2021, i.e. after you had been appointed as counsel, in paragraph 64, I stated in this decision, the defense may also request the SPO to provide Albanian translation of specific evidence or part thereof, other than statements of witnesses whom the SPO intends to call to testify at trial. When making such requests, the defense shall indicate the reasons why it is essential to receive these pieces of evidence in Albanian, and why the accused is not in a position to appreciate the content of such evidence with the assistance of an interpreter and counsel's advice. In the event of a disagreement between the defense and the SPO in this regard, the defense must seize the pretrial judge as soon as possible. I don't think that the last status conference, 2 days before the date I indicated I intended to transmit the case to the trial panel, corresponds to as soon as possible. So I think my decision was pretty clear. Why haven't you asked the SPO for the specific pieces of evidence? It could have been 1,000 pieces of evidence, but the procedure has been set since January.
Your Honour, that is correct. This is not the first time that we've raised this as an issue. This is the third time in which it's been raised. On the one occasion when we did inquire of the SPO as to the translation of a document in Albanian, we were informed that that's not their responsibility. It's not their responsibility to provide a translation. We then took that up with the registry. We were then told it would take 3 months to get that document. Of course, it was then accelerated. We received that document. That is unfortunately the process. I appreciate that many of these matters should have been raised before. They were not raised before. We were not aware at that stage, and there has been continuous disclosure as we go forward. All I can say is that if a further filing is required to identify those that we consider are necessary in order for this matter to go forward, then we will make that expeditiously. And when I say expeditiously, we will make it before the 16th of July.
Yeah, I think it's important that you point exactly which document you estimate that the translation is necessary for Mr. Haradinaj. Mr. Prosecutor, do you have anything to say on this matter of translation?
Yes, briefly, Your Honour. First, just to clarify that the one request received was in relation to the translation of the pre-trial brief, and our response was that we had no obligation to do so, knowing full well that the registry would be doing so. So there has been no denial of any truly necessary documents. Other than that, we have not received requests for translations of any other items. I don't need to say this because we all know what has been disclosed in this case, but we know that the bulk of the material disclosed is actually already both in Albanian and in English, especially, for example, the video evidence, for which we have the video evidence that contains audio in Albanian and also a transcription thereof in Albanian. Otherwise, yes, there is a difference of opinion, it seems, between the parties. The SPO's position is that the SPO and the registry are doing what is required to do according to the law and the rules. And the last thing I'll say is just that there should be no delay, be it to the transfer of the case to the trial panel or even to the start of the proceedings for reasons of translation, when it is clear that everything that the defense is owed, so to speak, is being or has already been provided to them in terms of translation. Thank you.
Thank you, Mr. Prosecutor. Mr. Roche, do you want to add anything on this topic? Maybe on the request that you received from the defense in the past months and what has been prioritized by the registry. You have the floor.
Thank you, Your Honour. Yes, the request we received was for the pre-trial brief, which we gave an initial indication of the likely timescales, and then were able to deliver significantly in advance of that, primarily due to shortened revision times. So we have ensured the priority translation of the documents in which that was requested in respect of, and in the event that we receive any other requests for prioritization, we will, in accordance with the applicable policy, which sets out a list of criteria, ensure that that is prioritized against the other workload of Language Services Unit. Thank you.
Thank you, Mr. Roche. Let me turn to the defense again. Mr. Rees, do you have anything to add on this topic?
No, thank you, Your Honour.
And Mr. Rees, same as I said to Mr. Cadman, if there is any outstanding translation that you require, please do so at the earliest opportunity so that this can be prioritized by the registry.
We will do. Thank you.
Thank you, Mr. Rees. Mr. Cadman, anything you want to add on this topic?
Your Honour, only to say that, contrary to what the SPO have said, we are not seeking to delay this matter going forward on the basis of that. What we are merely seeking is, once we go to trial, we will require additional material that hasn't been translated. That is the point that's being made.
Thank you, Mr. Cadman. This is noted. Let us now move to the next topic in our agenda, which is disclosure. I would first like to know whether the prosecution has finalized, and I say finalized, its disclosure, or if there are still evidentiary material that need to be disclosed to the defense. If it is the case, I would like the SPO to explain what material still needs to be disclosed and the reason for late disclosure. I would also like to hear from the prosecution if they will request protective measures for the witnesses who will be called to testify in this case before the trial panel. This information would be included in the handover document. And finally, I would like to hear from the defense on this topic, especially if they face other difficulties related to the disclosure process. And on this, I invite the defense to focus on the remaining difficulties because there has been a lot of debate. I ruled multiple times on that matter, so there is no need to recall the procedural disclosure history, but just to focus on what is still remaining, if any. Mr. Prosecutor, you have the floor.
Thank you, Your Honour. I'll address the protective measures request first, and I note that in our pretrial brief we did indicate that we would file in due course requests for protective measures in relation to the two prosecution witnesses, and we are further assessing that situation and will of course make such a request, which I believe would also be appropriate before the trial panel. In terms of disclosure, since the last status conference there have been a limited number of disclosures, primarily relating to items requested by the defense. We do not currently intend to disclose any further information. That obviously depends on if anything else is requested. However, we do not plan to do so. I will remind Your Honour and the defense who already knows this, but there is one as yet outstanding third-party request. We keep hoping to receive a response, and we are currently aiming or hoping for the end of July. And we will, of course, disclose any information received immediately. The case still remains that we do not anticipate that this would require any, for example, a redaction or have any 107 issues attached to it. So we are doing everything we can, but of course, as always, we do rely to an extent on, not to an extent fully rather, on external parties. And that's all I have for Your Honour, unless there's anything else.
That's it. And just for the benefit of the defense, you're referring to the second part of the request that we are still expecting. We've been expecting for a couple of weeks, if not months now, if I'm not wrong. Thank you very much, Mr. Prosecutor. I turn to the defense. Mr. Rees, please.
Your Honour, sadly, we do foresee continuing disclosure difficulties in this case. I will not rehearse the chronology because it is well known to Your Honour, but we have little confidence that things will be plain sailing from this point onwards. There remains an outstanding appeal in relation to a previous decision on disclosure that is yet to be ruled upon, although all submissions from all parties are now before the Court of Appeals panel. We do not, although we do envisage ongoing disclosure difficulties, subject to one issue which I understand Mr. Cadman intends to raise in closed session, we do not suggest that those ongoing disclosure difficulties should prevent the case file from being transferred to a properly assigned trial panel. Any further disclosure issues, it seems to us, are properly to be resolved by the trial panel in due course. In relation to the outstanding third-party request, it would be of some assistance if Mr. Pace gave some summary to Your Honour of the type of material that is expected, the volume of material that is expected. That would assist the parties in giving some planning for the next stage going forward, namely when the parties will be trial ready. Other than that, I have nothing further to add at this stage, Your Honour.
Thank you, Mr. Rees, and I have noted down your question. But before giving the floor to the prosecution, I turn to Mr. Cadman first, please.
Thank you, Your Honour. There's not much point me setting out what Mr. Rees has already said. We've already set out in our written submissions that we have little or no confidence in the matter going forward without further bumps in the road. We do fully expect there to be further bumps. Hopefully they're not going to be of the size that will disrupt these proceedings any further. But I think we've referred to the cavalier attitude of the SPO in relation to their disclosure obligations, and so we continue to have those concerns. There is one matter, possibly two matters, but I have agreed not to raise it in public session. I will deal with those two matters in closed session.
This is noted. And if you agree, Mr. Cadman, we can do it after the last point in the status conference, in the any other business matter. And I think you also agree that it's done in private session and in closed session. If
Yes, I think as I was explained the difference between private and closed. Yes.
Exactly, because we try to have as much publicity as we can, and in private session we still have the public being able to attend, and we still have the video. So
absolutely, Your Honour. I think
if it's possible, it's always better to go to
the matters are
session.
not of such sensitivity that it would require the curtains to go up. So certainly the curtains can stay down,
Thank you, Mr. Cadman.
or they can go down. Yes.
Let me turn to the prosecution. If you need us to go in private session to respond, let me know. No, I see that it's not necessary, so I give you the floor.
Thank you, Your Honour. I'll just say that in terms of Mr. Rees's request to provide information, at least to the pretrial judge, about the type and volume of material to be expected, all I can say at this stage is that the pretrial judge is informed about the general nature of such material. Thank you.
Thank you very much, Mr. Prosecutor. Mr. Rees, do you want to add anything?
Well, in light of that unhelpful response, there's nothing that I can add, Your Honour.
Thank you, Mr. Rees. Mr. Cadman, do you want to add anything?
Your Honour, I think the only matters that need to be dealt with in terms of disclosure affects more from a standpoint of the defence investigation, so I can deal with it when we address that point.
This is noted. Thank you. Let me now move to the next item in our agenda, which is the defense investigations. I invite the defense to provide an update on the status of its investigations, including the estimated overall amount and type of evidence it intends to disclose to the SPO, and whether requests for protective measures are envisaged. And again, this is for the purpose of including such information in the handover document. I invite the defense for their submissions on these matters, starting with Mr. Rees, please.
Your Honour, we have conducted extensive defence investigations. They are referred to in the course of our extensive defence pretrial brief. We have provided, as requested, a list of witnesses that we provisionally intend to call, which sets out both their identities and, by topic, an indication as to the issues to which they will, their evidence will go. We hope that that meets such requirements as are in place for defence disclosure at this stage. We are aware that when the matter is sent to a properly assigned trial panel, that there is to be further trial preparation hearings at which those matters will be revisited and fuller details given at that stage. There are some areas in which there may be continuing investigations. We do not envisage them delaying matters any further. We said to Your Honour at a very early stage, in fact, I think it was either the first or the second of these status conferences, that we intended to be trial ready shortly after the 30th of August. And we have reached that position as we said we would.
Thank you, Mr. Rees. And I remember very well, I think you've been very consistent with your timelines, whether it's for the defense pretrial brief or for the date of the beginning of the trial. Mr. Cadman, please.
Certainly, we are in agreement with Mr. Rees as far as the time frame is concerned. Obviously, the defence investigations have, to a certain extent, been coordinated between both teams and will continue to be coordinated in that fashion. As Mr. Rees had said, there is a strong likelihood that the investigations will continue for some time yet. There are still lines of inquiry that we are required to pursue based on our perception. We understand the SBO's position is not at all in agreement, but there are certain lines of inquiry that we have to investigate, and we will continue to do so. We have a number of requests outstanding that have recently been made to various different ministries and agencies in the Republic of Kosovo that requires information that goes to one of the defences that is set out in the pre-trial brief. We have also requested and will continue to pursue cooperation, or certainly we seek to interview a number of individuals in the Republic of Serbia due to their involvement in these matters. Obviously, if we have no cooperation from the Republic of Serbia, as we fully expect, due to their effectively still being a state of war between Kosovo and Serbia, then we will, of course, have to come back to request assistance. There is also a matter that, as we will deal with in private session, information that we will require as a result of matters that occurred last week. But again, we can deal with that in private session. We will also be looking at a number of other witnesses that may require protective measures. At this stage, we cannot give a firm indication as to whether those individuals will require or will request some form of protective measures, and we'll have to come back potentially before the trial panel to raise that at a later stage. But I think the court should envisage that there will be defence witnesses that will require some form of protective measures going forward.
And if I may, because this would be useful for the trial panel, do you foresee that it would concern one or two witnesses, or I think you have 20, I don't remember exactly the number in your witness list, but 20-something witnesses. Do you foresee it for most of the witnesses, or just for a few witnesses?
Your Honour, despite the pre-trial brief being filed confidentially, the names of those witnesses that have been listed do not require protective measures. There are additional witnesses that we were not in a position to name at this stage because they haven't given final agreement that they are willing to come forward and testify, because they are concerned themselves of potential repercussions from the evidence that they will give. We will come back to the court at the time in which we know what the position will be. I would not imagine it to be more than between 1 and 3 witnesses, but as soon as we are able to clarify that, we will.
Thank you very much. This is noted. Let me turn to the prosecution. Do you have anything to add on this topic?
No, thank you, Your Honour.
Thank you very much. I would now like to move to the last item in our agenda before the matters that we'll address in private session, which is the transmission of the case to the trial panel and the readiness for the case for trial. I would like to know whether the parties foresees any significant impediment to the transmission of the case file to the trial panel on Friday, July the 16th. In this regard, I remind the parties that the transmission of the case file does not automatically translate into the opening of the case pursuant to Rule 124. Further preparatory steps are first to be taken by the trial panel as foreseen in Rules 116 to 119. In any event, I would like the SPO to indicate whether it expects to be ready for the presentation of its case at trial, so this information can be included in the handover document for the future trial panel. For the same reason, I would like the defense to indicate when it expects to be ready for the presentation of their respective cases, if any. Mr. Prosecutor, you have the floor.
Thank you, Your Honour. Turning first to the transmission of the case file to the trial panel, no, we do not foresee any impediments to that taking place on the 16th of July as set out by Your Honour. We do take note of the Haradinaj defence submissions filed, I believe, yesterday, and that was filing 259, paragraph 27, where it seems that the Haradinaj defence is saying that the case is not ready for transfer to the trial panel for a number of reasons. And Our response to that is that there is no need for an order on the corrected indictment, so that is not a valid reason to defer the transfer. The matter pending before the Court of Appeals is also not a valid reason to defer the transfer to the panel. Any outcome thereof can be implemented equally appropriately before the trial panel. It's not clear to the SPO what specific request the Haradinaj defense refers to as being outstanding with the SPO, it seems. We have responded to all requests made. We can, of course, engage inter partes if there is anything else. And for those reasons, we do not see any impediment, as I said, to the transfer taking place soon. I believe that would be on the 16th. In terms of when the SPO would be ready for trial, as such, we will be ready when we are asked to be ready. We do know that, of course, a number of steps do have to take place, as Your Honour noted, both in his order and orally earlier today. It's not that a case is transferred and then trial starts immediately. There are requirements pursuant to the rules that have to take place, and based on how things are going in our experience, it would seem that perhaps the trial could start early November. But as I said, the SPO is ready for trial when the trial panel calls it to be ready. Those are our submissions, Your Honour. Thank you.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Rees, please.
Your Honour, we have already said that we see no impediment to the transfer of the file to a properly assigned trial panel, save in relation to the issue that I understand Mr. Haradinaj's team intends to raise in private session. That is the only impediment that I see at this stage. I will address Your Honour in relation to that, because I am supportive of their position, but clearly that makes little sense until Your Honour has heard what the issue is from Mr. Haradinaj's team. In terms of being trial ready thereafter, subject to listing and professional commitments, we maintain, as we have said from the outset, that we will be ready for the trial to proceed in the early autumn from September onwards, Your Honour.
Thank you, Mr. Rees. This is noted. Mr. Cadman, please.
Your Honour, as Mr. Pache has pointed out, there's reference in paragraph 27 to certain issues that have been raised on behalf of the defence. If Your Honour sees it, it's a question of being trial ready. As I said repeatedly today, Mr. Haradinaj does not want this matter to be delayed any further. We are saying that these matters can be transferred to the trial panel on the 16th, as previously indicated by Your Honour. There are certain issues that may need to be resolved, but we're not saying that these are a sufficient basis to delay matters any further. The issue, as far as the order on the corrected indictment is concerned, it is raised in passing as the rules appear to be silent on that question. And of course, the Code of Criminal Procedure of the Republic of Kosovo has a very, very different position. What I was suggesting was that there has been no order or no decision by Your Honour as to whether a further procedure is required. We can only assume from Your Honour's silence that you do not intend to issue any further decision or order, and it's flagged as an issue for Your Honour to consider. But I can see by Your Honour's reply, your silent reply, that what your position is.
And this is correct, Mr. Cadman.
As far as the outstanding request, I will have to go back to just to verify whether that has in fact been responded to. There was a previous request containing a number of different requests that were put to the SBO that have been replied to in full, except that there may well be additional requests that stem from that. It may just be an oversight on my part in saying that a further request will be made rather than a further request has been made.
Thank you, Mr. Cadman.
Your Honour, sorry.
Mr. Rees, you want to add something?
I do, only to clarify one matter. We, of course, acknowledge that the SPO has served a proposed corrected indictment. We take the view that whether that indictment is sufficient in its present form is a matter that should be reserved to the trial panel, and we therefore reserve the right to raise any further issue about whether the current proposed corrected indictment meets the decision handed down by the Court of Appeals panel. We do not raise that as any impediment for the file to be transferred to a properly assigned trial panel. But I wish to make it clear that our silence in relation to that document at this stage, when we have been otherwise preoccupied with completing our pre-trial defence brief and dealing with the ongoing appeal on disclosure, our silence on their submitted proposed corrected indictment does not mean that we accede to the submission that meets the Court of Appeals decision. We will review it, and in due course, and if there is an issue, we will raise it before the trial panel.
Thank you, Mr. Rees. This is noted. Mr. Cadman, do you want to adopt the same position?
It is adopted in that way.
Thank you very much. Let me turn to the prosecution. Do you want to respond to any point that have been mentioned by the defense?
Merely to inform the court, Your Honor, that when we did provide a corrected version of the indictment, we also provided an inter partes communication with a tracked version thereof, which will significantly facilitate any review the defense intends to undertake in relation to the corrections. Thank you.
Thank you very much. I don't see anyone asking the floor on this topic. So at this point, I would like to ask the parties whether they have any other issues they would like to raise. I note that the Haradinaj defense indicated that it intended to raise two issues in closed and probably private session. Before we hear these issues, do any of the parties have any other issues they would like to raise? Mr. Prosecutor.
Thank you, Your Honor. The only issue I'd like to raise relates to the matter of agreed facts. As Your Honor well knows, the defense in their pretrial brief, either Annex 2 or therein, included notes in relation to the facts agreed upon. And the SPO is ready to either, if the pretrial judge prefers, file information before the pretrial judge concerning that agreement, or if the pretrial judge so indicates, it can also be filed before the trial panel. And I say this mostly because while the Haradinaj defense team listed the facts agreed to, the Gucati defense listed only by reference to numbers, and the pretrial panel is not in possession of the inter partes communication, so the judge does not know what has been agreed to. But like I said, we are happy, if so ordered, to file this tomorrow before you, or it can wait for the trial panel as Your Honor would like. Thank you.
Let me turn to the defense on this. Do the defense have any opposition to filing by the SPO tomorrow on this point? And I turn to Mr. Bowden first, because I think Mr. Rees is not connected anymore. Mr. Bowden, please.
No, Your Honor, I think he may have had some difficulties with his source, namely his phone, I'm afraid. There would be no objections to the prosecution's position, Your Honor.
Thank you, Mr. Bowden. Mr. Cadman, please.
No objection at all, Your Honor.
Thank you very much, Mr. Cadman. Then, Mr. Pache, it would be fantastic if you could file it before, is it too much to ask you, before 4 p.m. tomorrow, so it can be distributed tomorrow afternoon?
Not a problem, Your Honor. Thank you.
Thank you very much. We are now going to move in private session, and I just want to check Mr. Rees is not connected anymore, correct? So we don't have any problem to move into private session. Madam Court Officer, can you let me know when we are in private session?
Your Honor, we're back in open session.
And I see that Mr. Rees is connected again. So before we end this hearing, are there any other matter that any party would like to raise? Mr. Prosecutor? Mr. Bowden, because I think Mr. Rees is disconnected again. Mr. Bowden, any other matter?
No, thank you, Your Honor.
Mr. Cadman?
Just one point, Your Honour. We are concerned as to this case being conducted more or less behind closed doors. As we know, an application has been made or will be made for the prosecution evidence to be entirely behind closed doors. We are also concerned by the matters that have been raised in private session that will impact upon the fairness of these proceedings. As a result of that, and it is not without precedent, we will be requesting that the OSCE or a similarly placed body conduct an effective and independent monitoring of the trial proceedings, because we are concerned as to how these matters are going forward. That is the only point I wanted to raise, Your Honour.
Thank you, Mr. Cadman. I note today that you wanted to be in closed session, and I'm the one who invited you to accept a private session so publicity can be preserved as much as we can.
Absolutely, Your Honour, and you're correct. And I have also been reminded of that fact by the Court of Appeals panel. There will be matters that need to be dealt with in closed session. The entirety of the trial is not a matter that needs to be dealt with in closed session.
Thank you, Mr. Cadman. I see that Mr. Patch wants to take the floor.
Thank you, Your Honour. Merely to note that I don't understand where the suggestion of the entire proceedings being conducted behind closed doors comes from. Even if the two prosecution witnesses were to be granted protective measures don't mean that a trial is held behind closed doors. It would mean that perhaps their identity is not known, their specific names are not known to the public. However, there is much which can certainly be said in public, and we look forward to that aspect. And it's an aspect, of course, which we believe in and is fundamental to the trial. And I will also note that when it comes to, for example, filings, whenever there has been a request to reclassify into public or otherwise, we have made our submissions and we have done what has been required of us. So we are certainly very much in favor of this very important principle. Thank you, Your Honour.
Thank you, Mr. Prosecutor. I don't see anyone requesting the floor. Then I inform the parties that I intend to transfer the case to the trial panel on Friday, 16th July, as indicated earlier. And in this regard, I also notify the parties that an order for reclassifications and public redacted versions will be issued on Friday. This concludes today's hearing. I thank the parties and the registry for their attendance, and I would like to thank the interpreters, stenographer, audiovisual technicians, and security personnel for their constant assistance throughout this case. The hearing is adjourned.
All rise.